Welcome to Legal Guidelines Prep for Florida Law Enforcement Officers. This is Deputy Z, and today I will be covering the Florida stop and frisk laws with regards to stop and detentions, when to frisk or not, items recovered as a result of a frisk, violent crimes frisks, seeing a bulge, presence at the scene of a crime scene frisk laws, furtive movements frisk laws, and case law on using handcuffs during a stop and frisk. A Terry stop, named after the landmark case of Terry v. Ohio, is a brief detention of a person based on reasonable suspicion of involvement in criminal activity, which is less than the probable cause required for an arrest and search incident to arrest. Reasonable suspicion depends on the totality of the circumstances, and both federal and state law require that officers be able to articulate the specific facts that support the reasonable suspicion. Pursuant to 901.151 of the Florida statutes, the following applies. 1. A law enforcement officer may temporarily detain a person to ascertain the person's identity and the reason for the person's presence in a given area under circumstances which reasonably indicate that such person has committed, is committing, or is about to commit a crime. 2. Detention may not be for longer than is reasonably necessary to make the above determinations. 3. The temporary detention may not extend beyond the immediate area where it was first effected. 4. If there is probable cause to believe that the subject is armed with a dangerous weapon, the subject may be searched only to the extent necessary to disclose and only for the purpose of disclosing such weapons. 5. A weapon or any evidence of a criminal offense may be seized and, if proper procedures are followed, used as evidence against the subject. Now for stop and detention. The Florida stop and frisk law does not allow an officer to detain and frisk a person suspected of violating non-criminal statutes or ordinances. The decision to stop and temporarily detain a person must be based on reasonable suspicion, which is something more than a hunch but less than probable cause, that the person has committed, is committing, or is about to commit a violation of a criminal law or ordinance. Officers can use 1. Their personal observations based on their training and experience, 2. Information from other officers, and 3. Information from a third party, so long as the third party is known to be previously reliable source of information and the officer knows the basis for the knowledge of the information being shared in order to establish reasonable suspicion for a stop and temporary detention. If an officer is relying on third-party information from an anonymous or uncorroborated source, the officer must be able to state evidence which corroborates the source. If the officer is unable to establish a basis for believing the source's information, then the officer should refrain from using this third party's information to establish reasonable suspicion. The Supreme Court has found that flight, aka running, at the site of police in a high crime area in and of itself constituted reasonable suspicion for an investigative detention under the Fourth Amendment, Illinois v. Wardlow. Cases have also recognized that nervous, evasive behavior, including unprovoked flight, and a pertinent factor in determining reasonable suspicion. See Illinois v. Wardlow. However, mere suspicion in a high crime area alone is not sufficient to support reasonable suspicion of criminal activity by that person. There must be a well-founded suspicion that criminal activity is afoot. See State v. Simmons. Under the stop and frisk law, a Miranda warning is not required, but will become necessary if the subject is arrested and interrogated. When the decision to stop has been made, the officer should announce his or her authority and identity badge, advise the subject of the purpose of the detention, then conduct a field interview to ascertain the identity of the subject and an explanation of his or her actions. Non-uniformed personnel should identify themselves by prominently displaying departmental credentials. The length of an investigative detention must be reasonable. That means it must be temporary and no longer than necessary to achieve a lawful purpose for the stop. If probable cause for arrest appears at any time after the stop, the subject may be arrested. However, if after inquiry probable cause for arrest does not exist, the subject must be released. The subject may not be transported from the immediate area of the stop unless there are compelling safety concerns, the subject consents, or the subject is arrested. And now the decision to frisk. A Terry frisk consists of a limited search of the outer clothing of an individual where an officer suspects to be armed and dangerous in an attempt to discover weapons which may be used to assault him. The decision to frisk and pat down is based on reasonable suspicion that the subject is armed with a dangerous weapon. You must not act upon the basis of a hunch. Be aware that there is no automatic right to frisk a subject during a Terry stop as a matter of routine. The officer must be able to articulate some specific factual basis for believing that the subject is armed and dangerous before conducting a pat-down. See Moore v. State. It is not enough to rely on the fact that others in the area or others arrested for similar crimes have had weapons in the past. See Hamilton v. State. Having stopped the subject for temporary questioning, indicators such as the following may cause an officer to believe that the subject is armed and dangerous, allowing for a frisk or a pat-down. A. Bulges which may be indicative of a concealed weapon. B, the subject's inability to account for his presence in the area. C, the subject's behavior, attitude, or demeanor upon being stopped, including furtive movements. D, the availability of backup officers and the number of subjects detained. E, whether the suspect crime involves the use of weapons. And F, the subject's past associations with those engaged in criminal behavior and reputations are known to the officer. If an officer has a reasonable belief based on specific and articulable facts, together with rational inferences from those facts, that a person whom she is detaining pursuant to Terry is presently armed and dangerous, and either observes that person in a vehicle or has articulable reason to believe that he has recently been in the vehicle, the officer may conduct a frisk of the passenger compartment of that vehicle. See Michigan v. Long. And do note, the stop and frisk law was enacted for officer safety, which should be the primary concern in such a situation. Now, items recovered pursuant to a frisk. If a frisk reveals an illegal firearm or other weapon, the subject should be placed under arrest, then a complete search may be made incident to arrest. If in the course of a pat-down for weapons, you detect an item that by sheer contour or mass makes its identity and criminality immediately apparent to you, for example narcotics, based on your experience and training, you may seize the object and the subject may be arrested on the narcotics charge. See Minnesota v. Dickerson. This is referred to as the plain field doctrine. For the plain field doctrine to apply, the officer must immediately be able to articulate probable cause upon feeling the object. If the frisk reveals a firearm or other weapon which is lawfully possessed, it should be safely returned to the subject upon termination of the encounter. Now, in reference to violent crimes, an officer cannot conduct a frisk merely because he or she has the right to stop an individual. He or she must also have an independent suspicion that the subject is armed. See Tarver v. State. The only exception to this rule occurs when the officer suspects that the individual has committed a violent crime. An officer can base a reasonable suspicion to stop and frisk on a number of factors. For example, if he or she believes a dangerous or suspicious movement of the suspects, or if he or she observes activity which confirms an anonymous tip, that officer would be justified in conducting a stop and frisk. Now, for a bulge seen on a suspect. Many stop and frisk cases revolve around a bulge which is seen on the person or the suspect. An officer cannot merely claim that he or she saw a bulge and expect that the court will uphold his or her right to frisk the subject. Obviously, if an officer observes the outline of a gun through a bulge, he or she can conduct a frisk. If the officer cannot identify a weapon and the bulge is in the waist area, he or she can conduct a frisk if there is some other indication of criminal activity. If the unidentifiable bulge is in some other area, such as pants pocket, jacket pocket, coat pocket, groin area, ankle area, a frisk is only authorized if the officer is responding to a report of a crime involving a weapon. A 1993 U.S. Supreme Court decision, Minnesota v. Dickerson, held that police do not need a warrant to seize narcotics while frisking a suspect for concealed weapons as long as the contraband is instantly recognizable by plain feel. Compare with Ray v. State, where no valid seizure when officer testified that he felt a plastic baggie in defendant's pocket, but offered no testimony regarding the contour or mass of the object within the baggie, instead saying he removed it because he knew narcotics are frequently packaged in baggies. An experienced officer who identifies a glass tube by plain feel can conclude, based on his or her prior experience and the totality of circumstances at the time and place of the search, that it is more likely than not that the hard cylinder object is drug paraphernalia. In other words, plain feel of a crack pipe during a lawful pat-down can provide probable cause to arrest. Also see fruits of a weapons search below. Where police officer had reasonable suspicions that a defendant was armed and dangerous, they made a justifiable protective frisk or pat-down pursuant to Terry v. Ohio. The Florida court held that the coins and straw removed from the defendant's pocket were able to be entered into evidence. However, the marijuana discovered by a police officer when he opened and inspected a Marlboro cigarette box removed from the defendant's pocket was inadmissible. Simply seeing a partially concealed firearm does not, standing alone, constitute reasonable suspicion or justify a frisk, as many people may lawfully possess a concealed firearm. However, if an armed person lies about possessing the firearm, reasonable suspicion for a frisk is established. Now, presence at the scene of a crime of a suspect. An officer cannot frisk a suspect merely because that individual is present at the scene of a crime. In State v. Rodriguez, officers arrested a person who they knew was only visiting a house when drug paraphernalia was found. The court held that there was nothing to show a factual basis for the officers to have reasonably believed that the defendant was in constructive possession of drug paraphernalia in the house they knew she was visiting, and held the arrest invalid. Nor can an officer frisk a motorist who is only stopped for a violation or traffic infraction. Probable cause is required to search the vehicle. See Pennsylvania v. LeBron. The warrantless search of an automobile pursuant to the automobile exception to the warrant requirement under the Fourth Amendment was held to be justified by the U.S. Supreme Court where probable cause exists. See Wren v. U.S. Now in regards to furtive movements. Furtive movements may be sufficient to establish reasonable suspicion justifying a pat-down search for weapons. See Lightbourne v. State. In Dewberry v. State, the defendant was a passenger in a car stopped for erratic driving in a high-crime and drug area. During the stop, while another passenger was jumping around, the defendant ducked down, possibly reaching underneath the passenger seat as if to place or retrieve something from under the seat. The court concluded that a pat-down search of the defendant was justified. Now, in regards to the use of handcuffs during a stop and frisk. The Florida Supreme Court has ruled that handcuffing a person while conducting a stop and frisk is reasonable when circumstances reasonably justify the use of such restraint. For example, the officer's safety or to thwart a suspect's attempt to flee. The continued use of handcuffs after the pat-down was held illegal. In one case, the police cuffed the subject during the pat-down but did not remove the cuffs after the pat-down revealed the absence of weapons, therefore making the consent to search given after the pat-down and while the subject was still cuffed involuntary. See Reynolds v. State. The case of Turner v. State provides an overview of some issues associated in a street encounter. Turner involved a response by officers to the scene of an alleged argument about drugs based on a tip from an unknown witness. When the officers arrived, they found no argument and saw no drugs or guns at the scene. All they found were two individuals. The court ruled that the search and subsequent find of weapons were illegal. Now, in reference to investigatory stops, there must be a well-founded suspicion that criminal activity is afoot, quoting from State v. Simmons. Hunch alone is not enough for investigatory search. See Smith v. State. It is not enough to rely on the fact that others in the area have had weapons in the past. See Hamilton v. State. Officers must have a founded suspicion that the person has committed, is committing, or is about to commit a crime before there can be an investigatory stop. Further, the law enforcement officer must be able to articulate reasons for his suspicions. Now, in reference to pat-down for weapons, according to Woodson, Supra, Section 901.1515 of the Florida statutes, authorizes a police officer to conduct a weapon search if there is probable cause to believe the person has temporarily detained is armed. Woodson relies on Dr. v. State. And that concludes our Florida stop and frisk laws.